That's why.
These are members.
Good afternoon, everyone. I think we're going to get started. My name is Kathleen Russell, and I'm your moderator today. I'm a founding director of Advocates for Child Empowerment and Safety, or ACES, and the executive director of the Center for Judicial Excellence in California. I've been privileged to work with Professor Meyer and others across the country for the past decade to expose and attempt to fix an ongoing crisis in our nation's family courts that is harming untold numbers of children. On behalf of today's briefing sponsors, ACES, the Domestic Violence Legal Empowerment and Appeals Project, or DVLEAP, and the National Partnership to End Interpersonal Violence, I'd like to welcome everyone to today's discussion. Today marks an historic moment, and for those of us who've spent much of our careers working to expose and fix the family court crisis that's harmed an estimated 1 million children in this country over the last 20 years, this day has not come soon enough. For decades, state family courts have been failing to properly hear and evaluate claims of child abuse and domestic violence during custody disputes. According to the Leadership Council on Child Abuse and Interpersonal Violence, an estimated 58,000 U.S. children each year are court-ordered into unsafe custody or care of abusive parents over the objection of caring parents. The resulting physical, sexual, and emotional abuse and trauma leaves survivors with a lifetime of physical and mental suffering. It also imposes billions of dollars in health and other social costs that could easily be avoided by safer custody and visitation adjudications. Quite often, an abusive father wrests custody of the children away from a safe mother by paying large sums of money to a mostly unregulated industry of professionals that are steeped in junk science. Despite this junk science being widely debunked by the American Medical Association and the American Bar Association, among others, it holds sway in many, many family courts nationwide, which you'll hear more about today from a few of our speakers. A multi-state study found that even in states with a presumption against custody to a batterer, 40% of adjudicated batterers received joint legal or physical custody. There's a purple sheet in your packets which goes into a bit more detail about this study and one other. Today, you're going to hear from a few brave mothers and a young woman who survived harrowing family court ordeals. You'll also hear from the Honorable former Congressman Greg Laughlin from Pillsbury, who will introduce Christina Thompson from Texas Congressman Ted Poe's office to discuss the historic House Concurrent Resolution 150 that was introduced on the House floor last Friday. Esteemed George Washington University Professor of Clinical Law Joan Meyer will give a brief overview of the family court crisis. Dr. Viola Von Eden from Norfolk State University will explain the need for professional standards for evaluators. And I will share with you some data we've collected about the 475 children in the United States who've been killed by a parent in the context of divorce, child custody, and separation over the past 9 years. The resolution can be considered a response to the 2011 findings and published decision by the Inter-American Commission on Human Rights recommendations in the Jessica Lenahan Gonzalez versus the United States case, which implored the U.S. to adopt legislation at the federal and state levels that will include protection measures for children in the context of domestic violence. I'd now like to introduce former Congressman Greg Laughlin, After serving 4 terms in the United States House of Representatives, representing the 14th Congressional District of Texas, Greg Laughlin has been in private practice at Pillsbury, Winthrop, Shaw, Pittman, focusing on public policy, energy, international trade, and tax law. A colonel in the U.S. Army Reserves, Mr. Laughlin was the only member of the U.S. Congress to see active duty during Operation Desert Storm in 1991. Mr. Laughlin retired from the U.S. Army Reserves in 1998. Prior to his election to Congress in '88, Mr. Laughlin practiced law in his native state of Texas, which he also points out he worked for, he's known Congressman Poe for 42 years now. They served together in the DA's office in Houston, Harris County, Texas. He also served on the board of directors of the State Bar of Texas from 1981 to 1984. Welcome, Congressman.
Thank you, Kathleen. Your remarks about the importance of why we're here today was far more interesting and far more important than what I've done in the years gone by, but thank you. My mother would have enjoyed that. It's important what you're doing here this several days that you're in Washington, D.C. Making child safety the first concern of any court is important. And Ted and I came about that naturally because we saw it in the criminal courts where we prosecuted. I tried an incest case that changed. Ted tried a rape case that he says the victim calls him 35 years later after seeing psychiatrist after psychiatrist, psychologist after psychologist, despite having a successful professional career. And he said, most people do not appreciate the violence and the abuse is almost always lifetime lasting for these young women and children. And that's why it's easy for people like Ted Poe and Greg Laughlin to join in this effort, and why it's so important for you to lead the education of members and staff who don't have the background that you have and don't have the background that Ted and I have, to realize what is happening in society. This is not a Republican or Democrat problem. It's not a liberal or conservative, rich or poor, black or white or brown problem. It's a people problem. It's an American problem. And if we don't address it, who will? Now, there's precedence for this resolution, and thank God I supported it in 1991 when Craig and Brendan and Chris, all lawyers in my firm, former members of the Senate and House staff in different positions, brilliant, and they make my job so easy I look better than I deserve. I'm not talking about physically, I'm talking about work product. They really do turn out high quality work, and what this resolution is a direct result of their skills. And the precedence was in 1991, Congress passed a sense of the Congress that the courts should have a presumption against custody to a batterer. How stupid or how difficult is that concept? No judge in his or her right mind would send their child, into a battered home situation. I cannot believe that would happen. So, what you're doing is so important. I've talked about Ted. Last week, Ted and I visited about the resolution, and let me just tell you, this is so important to Ted. You know he's struggling with leukemia, and he wanted this. And we have a lot of Democrat potential co-sponsors. He wanted and knew it was important, but he wanted this introduced before you got here. And the offices we've contacted are very interested, very committed, but they're working through various election season issues back home. And believe me, that's important to them. And so, as I said a moment ago, this isn't a Republican or Democrat issue or liberal conservative. It's a people American issue. It cannot pass. It should not pass without complete Democrat-Republican support. And we'll get that. And so what you're doing when you visit any of these offices, encourage them to get on this resolution. And Ted's committed. He would have been here. Last week he was going to be here. But he's wise enough, he's following the advice of his doctors. And he's at MD Anderson today. Was there yesterday. And last week he was going to be here today. So it's with pleasure I ask Christina Thompson, with whom I share a lot of commonality. Come on up, Christina. She and I are graduates of the same university, Texas A&M. She's a graduate of the University of Georgia School of Law, where my great-grandfather graduated in 1888, had the good judgment to immigrate to Texas, where he met my grandmother. And we've been there ever since, until I got loppy-headed and ran for Congress. Got it for a term. But Christina is the person, she's the executive director, unless I say the title wrong, of the Domestic Violence Caucus.
Victims' Rights Caucus.
Victims' rights. Victims' rights, domestic abuse, it's, to me, it's the same.
Yes.
Christina, thanks for being here representing Ted, and thank you for the hard work you've done cooperating with those of us from the Pillsbury Law Firm.
Thank you.
Thank you, and we look forward to hearing from you.
Great, thanks. Thank you. I'm just going to speak briefly for Congressman Ted Poe. As Congressman said, I am the director of the Victims' Rights Caucus. I work for the Congressman. As he mentioned, Congressman Ted Poe was diagnosed last July with leukemia. He has been in treatment at MD Anderson since then, and he is actually on his way back to DC, but was unable to make it in time for this briefing. But he did want me to express how sad he was that he wasn't going to be able to be here, but how excited he was to be in charge of this project. I would like also to share his very deep passion for serving victims and survivors of all walks of life and in any sort of situation that might arise. I know the Congressman, when I read him this resolution and he spoke with his good friend, Congressman Laughlin, was very excited to take the helm and lead this, and has not ever wavered his support and his dedication to get this done as quickly and as most efficiently as way possible. The Congressman was a judge in Texas for 22 years, so I think that he knows firsthand how important this issue is. This resolution, we sincerely hope, will encourage state courts to make child safety their #1 priority when considering visitation or custody adjudications. I'm not going to go into too much detail. I'll let the professionals and experts do that on what this resolution will do and hope to achieve. But we would just like to thank everyone for being here today. And I really appreciate all the work that everyone has done, especially Congressman Laughlin and Craig Saperstein. Y'all really did a great job getting this rolling, and we made great time on getting this passed, so we're passed on to the floor, so we're really excited about that. And I will leave my general office card and personal business card on the table, so if any of you guys have any questions or want to reach out to me about victims' issues, deal with the caucus, or just our office in general, please feel free. I look forward to hearing from any of you, and thank you.
Thank you, Christina and Congressman. I'd now like to introduce Joan Meyer, the Professor of Clinical Law and the Legal Director at D.B. Leap, George Washington University Law School, who'll give an overview and present some research on the family court crisis. In many respects, we wouldn't be here today if it weren't for Joan. She is a nationally recognized expert on domestic violence in the law, appellate litigation, and clinical law teaching. In her more than 20 years at GW, she's founded 3 interdisciplinary domestic violence clinical programs, 2 of which have provided legal representation, advocacy, and counseling to victims of domestic violence, and have been recognized by the U.S. Department of Justice as leading national models. In addition to her years of litigation and teaching, Professor Meyer has co-written several significant pieces of legislation and frequently delivers trainings to attorneys, judges, and other professional organizations. She has published widely on domestic violence and received the Kahn Award from the National Equal Justice Library for her article on domestic violence and welfare reform. You will see a longer bio of her in your packets, but suffice to say, Joan was really the fuel in working with, obviously, Congressman Poe's office to make this a reality, and please welcome Joan.
Thank you so much, Kathleen, and thank you so much to Congressman Poe's office and to the Pillsbury team and Congressman Laughlin, who really are the leading spirits between making our dream a reality. We've been talking, the whole field has been talking about doing something like this for a very long time, but it wasn't until we found Pillsbury that we were able to actually move it forward, and we are incredibly grateful. I want to confirm a little bit of the data that's been mentioned about this extent of the problem. I'm not going to do much on that. I'm going to mainly spend my time here. Why is that there? I'm going to mainly spend my time talking about how it happens that courts do the wrong thing in these cases. Because most people we talk to who don't know about it are like, how can that happen? That can't be happening. There must be something wrong with the mother, or it's not true, or the kids are this or that. They have to make the court make sense. And so what I'm trying to do here is explain the kind of sense that courts make, which we think is very wrong, and it's partly because they're being misled by professionals, and because they don't know what they need to know about abuse. But there are a lot of reasons, so I have the top 10 themes. I'll get to that in a second. But before I do, I just wanted to say that in addition to some of the data Kathleen mentioned, and there's other data in your packets in a research summary from D.B. Leap and also in the purple sheet, I'm in the middle, personally, of a 3-year federally funded study that's going to be gathering, that is already gathering and coding thousands of cases, family law cases involving abuse or parental alienation, or both. And when that study is done in the end of December 2017, we will have data, nationwide data, scientifically gathered, scientifically analyzed, that shows whether what we think is happening really is happening and to what extent. It will give us nationwide statistics and percentages. It will show how often women are losing custody, how often abuse is alleged, and what the outcomes are when that happens, and how parental alienation plays into those cases. We already have pilot data that's been quite stunning, so if anyone wants to know more about that, I'm happy to share at a later time. So I'm going to spend what's left of my time talking about how this happens in custody courts. Some of you know, maybe not all of you know, how subjective custody adjudications are. It's up to judges to decide what is in the best interest of children. And generally, statutes list a bunch of factors, and that's it. They may have a presumption, like the one that Congressman McLaughlin helped get passed 20 years ago, that says you shouldn't give custody to batterers, but it's a rebuttable presumption. And there are other presumptions, like the friendly parent presumption, which cuts the other way. And so statutes are complicated, and the bottom line is that courts have virtually complete discretion to decide what to do with custody visitation. And so how is it, what seems obvious, that if there's abuse, you don't give custody or unprotected access to the abuser? How is it that that's not happening? So I have my top 10 themes here. And these are all drawn from cases that D.B. Leap, my nonprofit, has been handling, or cases we've reviewed and tried to do an appeal for. Maybe we were able to, maybe we weren't. There are thousands more where these come from. Half the people in this room, I'm sure, can share and may share their own stories that are not that different. The first principle, the first theme, I think, is that many of these family courts have intense conviction that children must have two parents who are devoted to them, having both parents in their lives in every way. This is a quote from a very recent case from Florida. And when an opinion starts there, you know where it's going. Where it's going is, there's nothing you can tell me that's going to make me restrict the access of the second parent. And it also means, this is what we want. We want kids to have two parents. So we're going to make it happen through judicial fiat. And we are not going to listen to things that seem to get in the way of that agenda. And the sequelae, what comes from that is not only that we're not going to listen to the bad news, we're also going to blame the parent who wants us to hear the bad news, because she's standing in the way of this agenda, two parents. The rest of the themes I'm going to get into are all really derivative of this starting foundational principle that I think drives many, many family courts. Okay. This is old, but it still seems to hang on. It's the idea that upper class women can't be battered because they have options. So this is from a case, one of my very first custody and abuse cases in 2002, where the court said the mother cannot be a battered woman because she is not without independent financial resources, and she did not lack material and social resources. So therefore, she can't be battered like she says she is. In this case, actually, the mother and the abuser were both attorneys, which made it even harder for the court to believe, I think. Another case, more recently in 2005, the guardian ad litem, who was seen as an expert on domestic violence, was reputed to be, said, "This is not a typical domestic violence situation in that the person with the power and control in the relationship was clearly the mother. It appears the mother had control of the finances. The mother in this case was professional and professionally employed. The father was pretty much unemployed and hard to employ, not highly educated or skilled. And on that basis, it was decided that her story of abuse couldn't be true because she had financial power." We know, most of the people in this room know, and those of us who do this work know, that many, many people who are professional, who are highly educated, who may even have resources, and I think most people who start with resources end up without any, but even if they have resources to begin with, does not mean that they're not being abused, because abuse absolutely cuts across class. But I think it's very hard for family court judges to believe that upper class, well-presenting, and to be frank, honestly, white abusers, men can be abusers. They just don't fit the stereotypical images that drive many people's beliefs about what abuse is. Again, these are stereotypes that are not accurate, but they reside and they drive decisions. Okay, my third principle is out and out denial. So this is a case that we actually handled twice. Vivi Leaf did. I'm not sure where that's coming from. Anyone know? Make sure it's not my phone. Yeah. It first came to us in 2009, 2010, and we tried to take an appeal. The mother had lost custody to the abuser, who wanted to take the children back to Japan, where they used to live for a period of time. And in this case, he had already admitted to assaulting her, and she had gone to domestic violence programs where the counselors came to court and testified to corroborate her story of domestic violence. And yet, the court's opinion said, if all of this, well, actually said it out loud, if all of this abuse happened as you testified to, ma'am, I'm shocked that there's not any corroborative evidence of it. And I see this all the time. Judges will announce in opinions that there's no corroboration. I can go to the record and point to the police reports, the protection orders, and the other witnesses, but they will say there's no corroboration. I don't know what the translation is there, but it's a refusal to see what's there. She lost that appeal, and we were very sad and went on about our business. And then 5 years later, she came back to us because she got to see the children every summer. And every time they came here from Japan, they were worse and worse. In this last round, they were suicidal. They were reporting ongoing abuse from the dad, which was reported early on. They were acting out. Even the evaluators who supported dad said they were in a bad way, the kids. One of them had some uncontrollable tic. They were incredibly stressed. And she brought them for an emergency assessment at a child abuse agency at Virginia Commonwealth, and they said there needs to be a full investigation of child abuse. You know, credible concerns. What does the court say after all of that? The court finds that there's no abuse of the children and no history of family abuse. And he does that because the statute would have made it a little bit hard for him to do what he wanted to do, which was protect his prior decision and continue with custody to the dad, if he acknowledged that there might be some abuse, even though pretty much everyone in the case acknowledged that there were serious problems. The father had a rage problem, an anger problem, and that the kids were stressed, highly stressed by it. But he protected his decision in this way. We appealed this as well, lost again. Okay. What number am I on? Fourth. Misconceptions and ignorance about domestic violence, what I call it being snowed, or I'll know about her when I see one. The custody evaluator in this case in 2009 in DC, this was one of the appeals we handled, said, rather than presenting as abusive, he seemed quite passive. You know, it's understandable that people who know nothing about the field think that an abuser walks around acting like an abuser 24/7, that if he gets into an interview with a professional, he's going to be abusive. But these guys are smart, and they're not abusive 24/7. They're abusive when they feel like being abusive, which is typically with their intimate partner. And an evaluator who could say this is an evaluator who knows nothing about domestic violence, because batterers are very manipulative and very good performers. This has been known for decades. I thought that we had educated the courts about it. And maybe we had to some degree, but the evaluators have not been touched by the education of the courts. So that's one misconception. Another one is this one. An incredible opinion that just came down in Massachusetts, in which the court said, throughout the relationship, father was emotionally, financially, and sexually abusive to mother, and the stories were hideous. I'm sparing you the details. Father was unrelentingly controlling. His lack of support to her during her cancer diagnosis, treatment, and recovery is truly astonishing. So he called his number. He saw this guy for what he was in terms of the abuse of the mom. And then same opinion, he says, despite father's atrocious treatment of mother during their relationship, father has consistently been a good father to the children. Now, I ask you, how good a father are you if you're doing this to your children's mother? And why is it that we think that it's possible to separate the child's experience in the home from what's being done to at least one of their parents who they love? They may love both parents, but presumably they love their mother. And she's being destroyed by their father, and that he can't be a good father. He's creating trauma in the home at the very least. So that's one misconception, that we can totally separate domestic violence that happens between adults and children's exposure, or children's trauma, and children's risks. But it goes further in this way, and this is another huge misconception that I see in almost every case that I handle, which is that the problem's in the relationship, and once that's over, the kids will be fine. Because his abusiveness is to the mom. It's not to the kids. Now, this is assuming there's been no evidence about past child abuse, and sometimes there hasn't been. There's been no past evidence, but now that there's visitation, there's some problems popping up, like in this case, the same Massachusetts case, where the court reports that mother testified credibly that her son has been having bad dreams and her daughter has been increasingly touching herself inappropriately. Court accepts this as credible. This is since the visitation started, or the 50-50 custody, I think is what it was. And then he goes on to say, mother's position that the children are not as happy and playful as they used to be is not grounded in reality. In spite of the fact that they're having nightmares and one of them's touching herself inappropriately. Does that not tell you that they're not as happy as they used to be in itself? How can you say both of these things? Well, one way courts say it is that they just don't believe that someone who abused the mom is a threat to the children. And now, as I will be moving into in a later, I will get to in one of the later items, we want to go forward and not look back. And going forward, he looks like he's going to be a good dad. He says he's going to be a good dad. There's no evidence he ever wasn't a good dad. And so we're going to treat all of these reports, even though they're true, we're going to treat her concerns as not grounded in reality. And that's a hint of the pathologizing you see in these courts toward mothers who are trying to protect kids. Another theme, which I guess I'm at number 6, is that abuse, instead of calling it abuse, we call it conflict, or the courts call it conflict. So I have case after case where evaluators or GALs say things like this. This was a judge who said, it may not be knowable why the child was reporting sexual molestation, but it could be because, quote, she senses her mother's dislike for her father, and she senses her mother's discomfort, or is responding to her reactions to the visitations. These allegations are likely to continue because of the parental conflict. Okay, so the child is reporting, and you're going to hear from the mother in red over there, of this child in a minute. The child is reporting severe sexual assault, and this is being reported to the court, and instead of believing that, this is how the court is making sense of those reports. The child's fabricating because she's sensing conflict and hostility, and it's all it's about conflict. Going back to the more recent Massachusetts case, the court, after saying, yes, the children are having nightmares and touching themselves, but it couldn't be the father's fault, he then relies on the GAL who says that the children are caught between their parents, that the ongoing adult conflicts have left the children confused and shaken to the core. So we will take children's symptoms, we will take children's behavior, their acting out, their distress, their dysfunction, and their medical issues, and we'll attribute all of that to conflict between the parents, rather than saying, hey, maybe there's some abuse going on here. Okay, that goes on a lot in pretty much every case as well. Another version of the ways we silence or deny abuse is that courts will erase children's voices and conflate them with the mothers. They simply mark them out of the equation. The children have no voice and they have no experience. So in this Florida case that I cited a minute ago, the court said the court does believe that on at least a few occasions the father lost it with his wife and children. He downplays his acknowledged anger, control, emotion, and turmoil. And his story does not fully match up with his repeated need to apologize and beg forgiveness. Okay, this guy lost it angrily with children as well as wife. He apologized a lot. There was a serious problem, the court is saying. Then he goes on to say, the court does not believe that the children's complaints are a mirror of their own feelings and memories, but of their mothers. Even after saying they were part of this scene, they were subjected to this. Why would they not have their own memories? They surely do. And yet family courts are very quick to deny that children are people and have experiences, memories, and feelings that are entitled to be considered and recognized. And this sort of goes hand in hand with the junk science that says that basically mothers are capable of creating feelings and memories that are false in children. And I'll get to that in a second. Okay, so that gets to the next one that I was forecasting. A lot of this about how abusers to moms are not a danger to kids going forward has to do with the desire and the conviction that we're just going forward now. The past is over. Let's leave it be. So in this Tennessee case, the court says, the court is aware that Mr. R has admitted to physically abusing his wife on numerous occasions during their marriage. And then it goes on to say, Mrs. R has made no attempt to move on since the divorce and would benefit from psychotherapy with the goal of getting beyond her past and stop involving her children in her problems. What that's referring to is she's saying they're not safe. They're not happy. The visitations aren't working. And that, to the court, is just dumping her problems on the children, because surely there's no problem with this abusive man having access to his children. Again, another way, we refuse to look at the past, we tell the moms to move on, and we tell them that the kids' problems are a function only of the mom, they're not the kids' problems. And it's all about going forward. Now, one of the ways the courts are enabled in doing this is a kind of a junk science, and we see many different versions of that, and there's not time to go into a lot of depth, but I'm going to give you a couple examples, which is also a form of pathologizing of anyone who's reporting abuse, mothers and children. So this custody evaluator in Arkansas, another one of our big appeals that we did not succeed at, the evaluator says that the child's statement that, quote, my biggest worry is my father, and this is an open-ended, it's a STEM question to a child, it's a good type of thing. You say to the kid, what's your biggest worry? And then you see spontaneously what comes up. This is what came up. My biggest worry is my father killing me and saying my mother did it. It's a perfect capture of what abusers are like and capable of. But the evaluator says that's merely a manifestation of parental alienation syndrome, and that the boy's negativity toward his father is unnatural and abnormal. Well, it's unnatural if you have a good parent, but if you have an abusive parent, it might be quite normal. Does everyone in the room know? I'm going to guess that not everyone in the room knows what parental alienation is, although many of you I know do. It's a theory that's been propounded by many custody evaluators, and courts have really accepted it fully, to the detriment of children and moms, that when abuse is reported in a custody case, it's a way for the mother to alienate the children from their father. It is, and so it's parental alienation because it's an agenda, it's a strategy, and it's all about kicking the father out of the family. It has nothing to do with the truth. And unfortunately, this idea of alienation and treating abuse claims as a strategy has caught on so widely that it's very, very difficult to get courts to take abuse claims seriously on their face. They just immediately go to alienation. And evaluators like this help them do it. Another junk science example is the same guardian ad litem from Maine saying that despite the undisputed episodes of physical violence and threats, as well as behaviors by father that were strange, difficult, or even alarming, father was not a danger to his 2-year-old daughter because this situation was more like situational couple violence than coercive controlling violence. Another, I don't know if I can call it junk science, but another problematic labeling using a theory that's being developed and explored and researched in the social science field, but has not been thoroughly analyzed, that has a lot of problems in it, and it's being used to give a clean bill of health to people who've been violent, but if they can't find, they're not finding a totally coercively controlling dynamic by the abuser, they treat it as situational and therefore not dangerous. Because this theory says the dangerous abusers are the ones who use coercive control, and the other people who are violent aren't really that dangerous, maybe. There are a lot of problems with that. I'm doing a lot of scholarship on it. But anyway, this was way back then, and it had already infiltrated family courts to that extent that she basically gave this incredibly dangerous guy a clean bill of health. My other case in DC, Same theory, the evaluator, based on the theory that this was not controlling kind of abuse, called it violence with a small v. I don't know that the legislature, when it adopted its standards, has said that if there's violence, there's a presumption against custody, was thinking that there was violence with a big V and violence with a small v. And frankly, I don't think that's defensible as a matter of law, but we weren't able to get it changed on appeal because all of these discussions and decisions by courts are so fact-intensive, and you can't really reverse fact-finding and decisions by courts about what's happening, what's going on. You can't get that reversed on appeal on purely factual arguments. So the final, my final theme is what I call, if all else fails, ignore it. This was a case of amply reported and quite remarkably corroborated sexual abuse. In one instance, the child's report to one of the therapists resulted in the therapist thinking it was credible enough to report it to the state. Even though that therapist later stopped believing this child, she never backed off and thought that that original report wasn't credible. Nonetheless, the guardian ad litem in that case decided that he didn't really have to wrestle with the question of whether dad was orally raping his daughter, because it was not part of my job description to determine that. I did not think I needed to make that decision to make my ruling, he calls it. This is supposed to be a recommendation, at most, from a guardian ad litem. But he knows, and he's right, that whatever he says is likely to control what the court does. And he's like, okay, I can just ignore it. And the court goes with this opinion and one other, both of which say, we don't really know about sexual abuse, so we're really not going to get into it. But we don't really believe it, and the court goes with that. In this case, it was incredibly sad story. She lives, to this day, she lives with that father, in spite of our appeal. So there are many, many solutions that we're all working on, but that's the themes that I hope give you a sense and an insight into what happens in family court and how this happens. And I know there are many other fabulous speakers to come. Thank you.
Thank you, Joan, for that great overview. We're going to shift our program now into some personal testimonials. So now that you've understood how this happens from the court point of view, we thought it would be important for those staffers in the room who may be unfamiliar with this issue to hear directly from, we have one young woman whose parents were going through a contested divorce in California, and we've got her on video to share just a 2-minute synopsis. And what she shares is not unique and not uncommon. She actually testified at the California legislature on a child safety bill, and the members of the Judiciary Committee said, well, this is a very extreme case, and yet what we see and what we hear across the country is it's pretty extreme in a lot of states and a lot of cities. So without further ado, this is Rebecca Vale.
From the time I was 12 years old to the time I was 16 years old, the courts forced me to go to 12 different therapists, many of whom were abusive. The only reason we were going to therapy was so that they could take money from us. They didn't care what I had to say. They didn't care about me. My biological father was a drug addict and physical abuser, verbally abuse, emotional abuse, pretty much anything really. But he was a drug addict and alcoholic, and he abused my family as well as me. And I don't think it would be the best interest of the child if I had to spend half my time with such a person. I felt that my safety was stolen from me. I didn't feel safe anywhere. I felt that I was being stalked or could be taken away at any time at school or at home. I even mapped out places that I could run to just in case if someone did come to the school and try to take me away. I was scared. I didn't know what to do. Since then, I lost trust in anyone. To this day, I have trouble trusting people. We're sent to all of these different therapists who don't even care about what the child thinks or anything, and they just kind of use us for money. Like we're a little financial pawn that they use until our families are completely bankrupt. It's like no one will listen to a minor. Just because I'm younger than 18 years old, they think that parental alienation syndrome is in courts when it's not, because the family court system is very corrupt. They'll do exactly opposite of what is right.
Rebecca is in college right now. She's one of the lucky ones who survived her ordeal and lives in Sacramento, California. Now we have two very courageous moms who are with us today, and they're going to try to condense in many cases.
America, battered mothers are losing.
First, we're going to hear from a very brave, courageous mother and a corporate healthcare attorney here in the Washington, D.C. metro area. You have to recognize how difficult it is, as I was saying, to condense many years of this nightmarish litigation into 5 minutes, but our two moms today are going to try to do that. Please welcome Kate.
Good afternoon. Thanks very much for having me here. I just want to say first, all the things that Joan said in her 10 points, I think I probably checked off 8 of those. In my experience here in a court in the DC metro area, my time is short, so I will try to get right to the point. I want you to imagine something with me. I want you to picture, a 4-year-old girl. I wasn't going to do this. I don't normally do this. I want you to picture that little girl standing in front of you with a handprint on her face. A full-on handprint where you can see every single finger. I want you to think of this girl standing in front of you who has been hit so hard. And then I want you to picture that girl being held up like this by a man who's over 6 feet tall, being screamed at so loud, you think the windows will fall. And then I want you to picture that girl being shoved like a rag doll into a chair. Sorry. Now I want you to think of that girl also potentially being subject to sexual abuse. As I'm standing here trying to hold myself together, I imagine the human side of you thinks that something like this is not okay, that a little girl shouldn't have to go through this. And I imagine if I told you that the person that did that to her was a priest or a friend or a neighbor, and I looked at you and I said, I will never send my daughter back there again. Never. You would look at me and you would say, of course, no way, of course. That's exactly, we would never, ever, ever want you to do that. In this country, in fact, we have a system where sex offenders have to register so that parents can look up where they're living and know that if their children are potentially around somebody who's unsafe, because we want to protect them. And this all makes sense. And so now, if I told you the person who was doing that to that little girl was her father, and we were in the family court system, and that all the protections you think she should get would come to her, but exactly the opposite would happen, like Joan said, you would think that was completely silly. It wouldn't make sense. And you know what? I didn't think that either until I got into the family court system myself. And unfortunately, I'm not the only one. I speak for so many women across the entire United States who have the exact same experience that I did. And I don't have long to tell you, so I'm going to try to stress the very important things. And I think, until it happens to you, until you've been through this, until you know somebody, trying to get the courage to leave an abusive relationship is the most difficult thing in the world. And it's very easy to say when you don't understand, of course you should have gotten out, why wasn't it easy? And I'll tell you what, with kids, it's even harder. It's the most huge mountain that you have to try to move. And before I actually left my personal situation, I'm an attorney, and I started talking to some of my colleagues. And I told them what was going on. I told them the exact same story I've told you. And every single one of them said to me, there is no judge who is not going to protect you and your children. Of course they're going to protect you and your children. It's logical. And I believe that. And in my situation, I had to sneak out. I took my 2 children, and that was it. I had to make arrangements to leave, and I left with them. Neither one, we didn't have a toothbrush. We only had the clothes on our back, and I had to rely on family and friends to help us once we left. And then, of course, fast forward to my trip through the family court system, which I like to describe as Alice in Wonderland. It was the Twilight Zone. Nothing at all was what I expected it to be. And I really found a court system that struggled to understand, like Joan said, how a woman such as myself, an attorney, reasonably educated, could even end up in the situation that I was describing. Even worse, I had the same experience that I was coaching my kids, that I was making this up, and I couldn't understand how no one could understand the mountain that I just moved to leave that situation. I really can't even find the right words to describe to you the pain of being ordered by a stranger, whether it's a judge or a custody evaluator or a therapist. The babies that you just tried to leave with have to go back to the person who was abusing them and you. And not only do they have to go back, they're now going back alone. I can't even believe anybody in their right mind would think that this is an okay thing to do, but again, it happens every day across the country. And it's so difficult to explain to your child that you really have no choice. My choice was go to jail and defy a court order, or send them into a situation that I knew was dangerous. And every time I sent my kids to visitation, every single time, I had a pit in my stomach. And I wondered if they would come back alive. I wondered why nobody would believe my fear. And every time they showed up again, I thank God that they weren't dead. And I knew every time they left that the greatest revenge my ex could get was to take them away from me. My case went through the family court system about 4 years. It was nonstop. In the early stages of my court experience, I was in court probably once every 6 weeks. When I left my abusive relationship, I was on my way to being a partner at a large international law firm. I had to leave that job due to all the time I had to spend meeting with my attorney, preparing for court, meeting with therapists, both for myself and my children, and meeting with custody evaluators and child protective services. It was literally a full-time job. And I just now, in my short amount of time, want to give you a few examples of my experience, which again is completely support what Joan was saying and why this is just so incredibly important. When I left, my daughters were 2 and 4 years old. I immediately took them to a child therapist because I wanted to make sure that I was helping them and me. My daughters, as you know, experienced similar violence. We went through a series of evaluations, including an evaluation with a custody evaluator. In addition to what was going on, one of the therapists that I took my daughters to actually raised the potential of sexual abuse. This is not something that I came out the door with. I didn't have an idea, but she pulled me aside and said, based on my observations, I think something serious is happening to your daughter. So we went to a custody evaluator, and what I want to read to you is the conclusion that the custody evaluator made in my case. And in short, he says, however, his substance abuse evaluation has raised concerns about his parenting style, and the sex offender evaluations have also raised serious concerns. This examiner has seen instances of excessive anger in which situations in which my ex had been frustrated. The next 2 paragraphs of this report recommends joint custodial arrangement and recommends that my daughters live half the time with their father and half the time with me. And this is 1 paragraph after he has recognized that the sex offender evaluation has raised serious concerns. And the cost of this evaluator for me was close to $40,000. And that's what I had to pay. For that. Yeah, for somebody to recommend that my daughter go back to somebody who's potentially doing that to her. I'm about 7 years out of my situation. My total cost, I'd say, was over $250,000, at least between custody evaluators, attorneys, therapists, everything else. My parents are local. They both mortgaged their houses to the hilt. They sold furniture. They did everything they could to help us pay for all of these expenses. By the family court system, with all the things that come up that Joan said, they really have their potential in their lives snuffed out. And it's heartbreaking and it's sad and it's worse to watch when it's your own child, and children are not chattel. And the best interest of a child is to make sure that they grow up to be healthy, productive members of society, and that they are protected from the abuse that they should not have to endure. Thank you.
Thank you, Kate. We are going to have a Q&A session with staffers at the end of the briefing, so I hope you can stick around for that. I'd like to introduce another courageous, protective mom here from the DC area, Cassie Wilkins, who fought for years to keep her daughter safe from a sexually abusive ex-husband.
Good afternoon, everyone. Good afternoon. I want to thank Joan Meyer. I always want to, point out how she really helped me, and I always state that she really saved my life. Not only did she save my life, she saved my daughter's life. And I really appreciate you. I do apologize that I don't have the finances to thank you or to deposit that into your life, but I really appreciate all of your hard work, and thank you so much. Just want to share, and to the congressman in the back, thank you for being here today, and I'm really hoping that what's being said today will help to change so many lives and to save the lives of our children. Just want to start out by saying, maybe a little over 10 years ago, I experienced my worst nightmare. I was a new mom, and I was excited about being a mom. Unfortunately, things didn't go too well with my marriage, and I myself became a victim of domestic violence. And I struggled with that, and I, recalled so many experiences that I went through with my ex-husband, and fleeing and fighting for my life, and having my hair snatched out from the roots of my scalp, kicked in the face, and all kinds of things that I would never imagine. So that was fine. We had this little girl, and of course she would go to spend visits with her father. Thinking that everything would be fine, I went on and sent her because, I felt that whatever he and I had going on was just between us. Until, finally when my daughter was becoming more verbal and vocal, before she was verbal and vocal, I had started seeing little body languages that just really concerned me. But of course she wasn't really saying anything, so I couldn't do anything. Until I would say when she was maybe about 3, or 3-ish, or something around that 3, maybe 3.5. She returned from a visit. Prior to this, she was having nightmares, and I was wondering what was going on. And she returned from a visit, and she said, "Mommy, my daddy touched my poo-poo." So I really tried to keep my composure. I'm not, expecting to hear this. I didn't know what to do. I never dreamed that this would happen bad enough. I had been through what I had been through, and I thought that I was free once I exited that marriage. But now I'm seeing that something's going on with my daughter. So she says, "Mommy, my daddy touched my poo-poo." I didn't know whether to call the police or who. I immediately picked up the phone and I called the pediatrician, scheduled an appointment, took her in there, and after talking with the pediatrician, she kind of guided me through the whole process on what I needed to do. So it was during that time, not only did she say that my daddy had touched my poo-poo, which she was referring to her, vaginal area, she said my daddy put a stick in my poo-poo. So At this point, I'm reported it to the detectives, and instead of me getting the help that I needed, I thought seemed like the police and, who was a part of the judicial system kind of looked down on me and frowned as if I was making up something. And because of that experience, because of Joan, and because of all the psychologists and the social workers, I knew it that day that I had to obtain my own degree of social work. And now today, I'm a child welfare social worker with the District of Columbia Child Protective Services. And one of the things I talk to my children about when I evaluate them is, has anybody ever talked to you about good touch and bad touch? And when they answer, and I say, well, if anyone touches you inappropriately, who can you tell? And I tell them it's about crisis prevention. You have to tell someone. Thank you so much.
Thank you, Cassie and Kate. I know it's very difficult to relive that experience with us. I want to next introduce Dr. Viola Von Eden, who's an associate professor and PhD program director with the Ethelyn R. Strong School of Social Work at Norfolk State University in southeastern Virginia. She's a clinical and forensic social worker and serves as a consultant and expert witness in child maltreatment cases, principally sexual abuse. Thank you, Dr. Von Eden.
Thank you. I realize I only have a few minutes, and I think you've heard from the three previous speakers, and I would love to tell you that everything they said isn't true, but unfortunately, I've lived it and relived it. My background as a forensic social worker and working in child abuse cases really started in the mid-'80s. I worked as a psychiatric social worker in a residential treatment facility. After 10 years of that, we opened a child advocacy center, an actual child abuse program. It's currently an accredited program housed at a local children's hospital. That was 1995. So they've asked me to talk to you about the difficulties with evaluators, and you've heard from each person some of their struggles with the court, as well as evaluators and making decisions that are so harmful. So I'm going to briefly give you a few examples, but if you can multiply that by thousands of cases. I've actually myself evaluated more than 2,000 children who've experienced abuse or suspected of abuse, and I've actually testified in court more than 500 times, not just in Virginia, but throughout the country. And when I first had a very difficult case, very similar to what you've heard here, it was a 4-year-old little girl, and I was the evaluator, and I wrote the report. I went to court, and one of the biggest struggles for that mom was, like you've heard here, it was a catch-22. Social services had told the mother that if she did not remove her child, the 4-year-old who disclosed to the pediatrician, would be removed from her care, as well as all of her other children. But when she got to court, the judge, for whatever reason, believed that she wanted to separate from her husband and that she made it all up, and he then proceeded to say, essentially punish her by removing her children. I tell you about that case because it was an eye-opening case for me. It was about 15 years ago. I couldn't believe, I had to think that there was some mistake or some glitch, or that this was just one case. I then proceeded to go on the internet. I then proceeded to call colleagues around the state, and then ultimately met people throughout the country who shared with me that no, this is not a problem just in southeastern Virginia, this is a national issue.
Thank you, Dr. Von Eden. And we're down to the last speaker here, and I know we want to end as close to on time as possible, so I'm going to greatly truncate my remarks.
Next year, getting it actually into print and publication can sometimes take longer, but in terms of information that we are confident of, that that is valid, that is thoroughly woodshedded, I'm hoping we'll have that by the end of next year, and we might have a rougher version of that earlier. We do have already pilot data, which is the data that I submitted to NIJ to say, look what we can find, we think, if we do the bigger study. So the pilot data is quite informative and quite dramatic, but it's not anywhere near as big, and it wasn't as thorough. I possess it, I can share it. I'm actually going to be publishing it in the next 6 months. I haven't actually put it in print yet, but I presented it a few times, and I can certainly share some slides of that, if you'd like. I've been rolling it into different presentations I've done. Happy to share that.
Great. And also to respond to Congressman, the data about the child mortality is available at the Center for Judicial Excellence website, and it's an ongoing project that we're consistently updating information so that we can get that to Pillsbury as well.
Thank you.
Any other comments or questions?
I'd like to not only compliment everybody on the presentation because it's very informative, but I also appreciate from Dr. Eden, thank you for explaining and articulating some of the dynamics that the professionals have demonstrated, because that's what we've all run into. And it was nice, you really did a great job laying some of that out, how it came to be, because when we try to explain to other people the kind of individuals that are accessing who are not qualified, they don't quite get it. So thank you for breaking that down. It was a very nice job. Thank you.
One of the, just in response to that, if you think about your primary care physician, who I love my primary care physician, he's wonderful, but whenever I have something that is special that's happening, he's going to make a referral. He's going to send me to a specialist. If I start having a heart problem, if I'm diagnosed with cancer, he is going to send me to a specialist. He's not going to try to operate himself, even though he may know something about the heart, even though he may know something about cancer. If we put this in the context of some of our public health issues, there's absolutely no way that this problem would not have been dealt with sooner.
Thank you. And Heather, did you want to share a few thoughts?
I just want to introduce myself. My name is Heather Boltz. I'm from upstate New York area.
Heather, could you speak up a little? Yes, thanks.
I'm
Or
from
maybe
upstate New York.
maybe come up and
Okay. Thank you. And I'm here with a case that has lasted over 17 years. Can you hear me? No. No.
You can
hear
us behind you.
Okay. Okay. Thank you. And I just had a couple of thoughts. I wrote them down. But 14 years ago, I went into shelter with my children, seeking safety from abuse. I want you to know why we left. The abuser had fractured my face, held me and my children hostage for over 4.5 hours, and caused me to have permanent brain damage. The clinical term for my condition is chronic encephalopathy. You might know that term because it's also what happens to football players when they get multiple brain traumas to their head. There was also a movie made out of this. I left with my children, most importantly because he started to take out his violence on them. There was a pattern, and one I knew all too well, because these cases have a pattern to them. I saw this slow progression starting to happen to my children, and I left. It was the hardest decision I ever made. He promised us he would take everything away from us if we ever left. He was able to make good on those threats because the family courts actually help abusers in custody visitation cases. He was awarded full custody by the family court after I left the violence with my children. This was despite 2 criminal charges for felony assault for fracturing my face, felony imprisonment for holding me and my girls hostage, despite multiple restraining orders over the course of many years, despite a lengthy domestic violence arrest record, despite multiple child protection services involvement in New York indicating him for abuse of my children and neglect of my children. Despite those reports that said I should remain their primary caregiver, I did everything right and this still happened to me and my children. Once he had custody, he moved my children 1,800 miles away to Florida, and he successfully denied me access to them almost completely for those years. My oldest daughter escaped the abuse when she was 15. She was given emergency jurisdiction in my home state of New York. She told the court she had been thrown into walls by him, he had suffocated her, and she was self-harming due to the abuse. She wanted to die. It was literally a living nightmare. After 10 years, one of my children was protected, but with permanent damage. My other daughter still lives in this situation. She has tried to commit suicide multiple times. She's left in this home unprotected. The judge in Florida told me that she felt that the children were in danger, but she refused to protect them. My children were failed by by every family court that had this case. There were 3, including 7 judges. The gravity of what is before us is a massive undertaking, one that is going to take many years of work to help bring change. This resolution is the first step in that change for abused children. My daughter's voices, if they had been heard years ago, resoundingly begged for safety. The only thing that mattered was their safety, and it was ignored, and they are paying a lifelong price for this. Those of you who have children, I want you to do something later today when you see them. I want you to hug them and hold them close and realize how blessed you and your child are that they live in a safe and loving home. We want this for all children. Our parents want to bring their children home. Please support Resolution 150. Thank you, fellow champions for children.
If folks have a moment to stay, we just had 2 more moms. Is Leora Rosen here? Did you want to say a few words?
Well, I'm not actually a protective mom. I'm just a...
Yes.
I'm responsible for one of the pages in the handout, so I don't know if there's anybody here who has any questions about the sheet that talks about safety of...
Yes, the purple sheet
the
is
purple
here.
sheet here that talks about safety of custody rulings in 2 studies that which I did secondary data analysis.
Yeah, why don't we have anybody interested in hearing about that
wants to
talk to you afterwards?
Absolutely.
And then just one other personal story, and then we'll wrap up for the day. Catherine, would like to come up.
My name's Catherine Campbell, and my story mirrors many of these stories here. My children disclosed sexual abuse by their father. These boys were only 4 years old. And this is in California, in Santa Clara County. When we were not believed after multiple evaluators actually wrote in documents that the boys denied the abuse, which they never did. They had to report that. The evaluators actually then on the stand, even though the report says they denied the abuse, on the stand they had to say that it was never denied. They wanted to take away custody from me. They just decided to blame me instead. So what they told me to do after one of the evaluations was that I had to tell my children that they were not abused. I had to tell them that they were safe, and I had to promise to never report him again. So my children who constantly tell me that they were sexually abused by their father, I had to negate that. They came to me, the person they believed, and I was the one who had to sit, as I was told, with a family counselor for 6 weeks. And if I didn't convince my children that they are delusional, I guess, you know, everything you said is wrong, and your dad's safe, then I wasn't allowed to have custody. I refused to do this. I said, I'm not going to invalidate my children. I am not going to tell them that they're safe when they tell me they're not. And I'm not giving up my right to report a crime. The abuse was substantiated with CPS, and still the court refused to see it. Instead, I lost custody of my children, and they are still forced to live with their father. It's very sad. Their counselors have told them that their father's their father, so they need to improve their relationship with him, and that's their job. They were told that their father's their father, so that's why they need to live with him. They were told I was not well, and when they came back, after they continued to tell more and more people, and it was very hard to keep the abuse silent any longer, with CPS substantiated it. When they substantiated it, they actually forced us into 50-50 custody and told the children that they actually have to forget the past and not talk about it and go on. My children have suicidal thoughts, stopped going to school, and depression. We are so grateful that some children have been rescued and believed. Children need to be believed. This is a wonderful step, this resolution, to helping people believe children and helping experts have the correct training. They get trained now to discredit. Joan did such a great job presenting everything. I think everything that she said we have gone through as a family. As a family, we've spent over $2 million. Like, we're venture capitalists funding this cottage industry. And you will have a parent spend their entire savings to protect her children, and you will have an abuser spend all their money to protect their image and stay out of jail. We do need this resolution to pass. We are asking everyone to support it, and we need everybody's help. My children may never recover, and we see that children actually can recover, and it's taken their children years. Our children have gotten counseling, and it has only hurt them. If they are told they cannot talk about the abuse, they will never heal, and it only gets worse. So we thank you for your support, and we thank you for being here today.
Okay, so to end on a high note, our first article about the resolution has just been posted on ProPublica.org, and they say if you have experience with or information about family court, particularly the role of forensic evaluators, to email joaquin.sapien@propublica.org. There's a wonderful picture of Congressman Poe and quotes from the congressman in this article, which just posted this afternoon. So the media is paying attention, Congress is paying attention, thanks to Representative Poe's leadership, and hopefully many others in the Congress will step up and co-author this important resolution. Thanks for everyone's time and attention.
We really need your help in one area. We've had a couple officers say, why are there no Democrats on here? and it's a good question if you don't know the answer. The answer is Christina's called several officers. My colleagues are Democrat staffers. I was a member of both political parties, so I've got reached, and we've reached out to Democrat offices. Unfortunately, timing got in the way. When we started reaching out, there was no member of Congress here. They were in the middle of the August break. They've been at the 2 conventions. They've been out for the entire month of August. It was hard to reach. Staff will not and should not give a decision without talking to the member. And so then we get Ted gets hospitalized at MD Anderson with chemotherapy and all the treatment for the leukemia. And Christina will vouch, we are waiting. And so if you call on any Democrat office, say, we're waiting on Democrats, it will not go forward without Democrat support. Can't, and shouldn't. So if you're in any Democrat office, please ask to call Christina.
Thank you. There are lots of progressive Democrats from California here, so I know we have many meetings with Democrats. There's a Democratic staffer in the room.
Congressman, I represent Democratic Congresswoman Carol Maloney, and I know I am free to speak for her to say that she thinks you are all heroic and doing the Lord's work and the talk.
Yeah. Somebody call Christina. She's the gatekeeper.
Absolutely.
We need it and want it. So.
Well, this is just the beginning of what is going to be lots of work. So we thank everybody for coming, and we're just getting started. So thank you, and thanks to Pillsbury for all their tremendous work.